if, let's say, for instance, there's 5 persons that planning to commit an offense, and only one of them commits, the other 4 is also held liable exactly in the same way as the other one.
If you join a group or a gang and you know that the group is going to commit a particular crime, and you associate yourself knowing quite very well that this particular group is going to commit a crime, and you know what might be the consequences of that crime, then you are the creator of your own demise.
Wow, these pearls are really beautiful.
Yeah, I prefer the diamonds in here, do you think?
I love pearls. They look like a nice ring as well.
Compliment your outfit.
I'll totally match those up over there. Oh, these pearls are really beautiful, eh?
Yeah, okay, Pras. Clear, sure, I'll
Hello? Is there anyone inside? Hello? Is there anyone inside? This is Inspector Daniels of the SAPS. If there's anybody inside, please identify yourself immediately.
The state does not need to prove each and every individual's action or contribution to that particular crime. All what the state needs to prove is that all of them, they associated with the group, knowing quite very well the plan.
Brothers Mandla and Beki Shabangu were arrested that night. The next day, while in custody, they met with their legal aid attorney to learn what charges they were up against.
The state has decided to not only charge you with breaking and entering and attempted theft, but also for the attempted murder of Inspector Daniels. I'm not done. They are also charging you for the murder of your friend Andile, who died after being shot by Inspector Mlando.
What? They can't charge us for that. We did not kill Andile. Let the police Andile.
We did not even touch the cop or Andile. I'm Baba.
I know it seems strange, but the state believes that you all should be held accountable for what Andile did to the inspector. The state also believes that you are responsible for his murder because he was a part of your gang and you all committed the crime at the shop together.
I don't understand. But Mna, I am not going to jail for murder. I mean, I've never touched a gun or nothing.
So because Andile tried to kill that cop, and because Andile was with us, we are being accused of attempted murder. And then the cop shoots Andile. And we are accused of his murder as well. The cop killed our boy. And we are accused of murder.
You're being charged on the basis of the common purpose doctrine. An entire group can be held accountable for the actions of a single individual within that group if you are all part of it for a common purpose.
This is crazy.
The Constitution provides that every accused person has a right to a fair trial, which includes the right to have a legal practitioner assigned to the accused person by the state and at state expense if substantial injustice would otherwise result. Legal Aid South Africa provides legal representation in serious criminal matters for accused persons who cannot afford to pay lawyers' fees.
Section 35 of the Constitution entails the rights to a free and fair trial, which amongst other things entails the right to legal representation. The trial of an accused person would not be fair if he is not legally represented. The prosecutor on the other side is a legally trained person, a person who has a legal degree, a person who stands up in court almost every day representing the state's interest. The accused also is entitled to have a legal representative defending his rights, because if that were not so, there would be substantial injustice that he suffers. Legal Aid South Africa uses a means test to determine whether a client qualifies for legal aid or not. In the case of a single person, the limit or the amount of money they must earn as a net income is 5,000 rand. If it's a household or a married person, the joint household income should not exceed 5,500 for them to qualify. And that's the means test that we apply. In criminal cases, we don't look at merits. However strong or weak your case is, we will defend you. Whereas in civil matters, we look at merits because we would not be representing or taking cases that don't have merits. We would be wasting taxpayers' money if we were to do that.
The perception that the Legal Aid Board and the National Prosecution Authority work together in trying to convict and sentence an accused, it's an ill-founded perception. All lawyers that represent accused in court have to work together with the National Prosecution Authority in terms of arranging dates, in terms of sharing information, and if needs be, in terms of plea bargaining. That happens both to with respect to Legal Aid Board lawyers and lawyers from private law firms. So the question is procedural and the management of the case, rather than dealing with conviction and dealing with sentencing. In any event, the conviction in court depends on the presiding officer. The sentencing also depends on the presiding officer. So whatever applies to the Legal Aid Board lawyers exactly applies to the lawyers in private practice.
Coming up, the rest of the gang members are brought into court and the security guard turns state witness.
I was contacted by the group of accused and paid to act out as a lookout for them.
According to the doctrine of common purpose, where two or more people agree to commit a crime or actively associate in a joint unlawful enterprise, each will be responsible for specific criminal conduct committed by one of their number which falls within their plan. Liability arises from their common purpose to commit the crime.
In our criminal justice system, in order for one to be convicted of any criminal offense, there ought to be a causal nexus between one's individual actions and the ultimate criminal consequence. If we are say X is a perpetrator and D is the deceased, there must be a causal nexus between the actions of Mr. X that led to the death of Mr. D.
A various number of actors in a criminal enterprise or a group of persons that intends to commit a crime blend together and foresee that whatever they plan is going to end up being a criminal consequence. Or further, whilst planning that, they foresee another criminal results coming up as a result of their activity, but still continue to act nevertheless.
Mandla and Becky Shabangu were brought before the High Court as co-accused and charged with the crimes of housebreaking, attempted theft, murder, and attempted murder.
In the present case, Your Ladyship, the co-accused were all well aware in advance that they were going on a breaking and entering expedition. I submit, Your Ladyship, that the criminal group planning the break-in foresaw the possibility of getting caught in the act and therefore foresaw all the risks that go hand in hand with getting caught, such as the arrival on the scene of armed police officers and the possibility of death of either one of the police officers or one of their own group. Your Ladyship, if it is proved that a group of people acted in a common purpose to commit a crime other than murder, such as housebreaking, and in the course of executing that common purpose someone was killed, the fact that one perpetrator caused that death means that the legal responsibility of that death can be attributed to the other members of the criminal group.
Your Ladyship, the fact that the group of co-accused foresaw the possibility of being caught does not mean that they foresaw the possible consequences of being caught, that they had planned to put up a violent resistance if being placed in a high-risk situation. Precisely because they recognized the possibility of being caught, they took extensive steps to prevent this by making extensive plans with security and planning arrangements. In the present case, the dangerous resistance offered by the deceased co-perpetrator was not in the form of a firearm, but by the way of a crowbar. The group of accused could not have subjectively foreseen that one of their members would arm himself, using one of their housebreaking tools to attack an armed policeman. I submit, Your Ladyship, that after extensive planning on part of the accused group, it is questionable why the state would attempt to hold equally accountable the others for the actions of the deceased without solid evidence that the others could in fact have foreseen or known that their colleague would have reacted in such a violent manner.
In this case now, if you go with a group, there are principles first which should be satisfied before one can be convicted as well under doctrine of common purpose. Number one, the first principle is that if one is aware that this particular group is going to commit this crime. Secondly, you associate yourself with that group. You know as well that some weapons or firearms or any other dangerous weapon might be used, which might cause the death of another person, and you are present, in fact, when that plan is executed, then you will definitely as well be found guilty. And the action of the particular person who pulled the trigger, even if you did not have a firearm when you associated yourself with that group, if you did not have a firearm, you did not have even a bread knife, and the person dies as a result of a gunshot, you will be as well sentenced and dealt with as one who had the firearm and who pulled the trigger.
And people might raise all sorts of arguments, like it was raised in this specific case, that I didn't know that so-and-so had an instrument or had a weapon, so I should not be held liable for what he has done. I should be held liable for what I was party to planning. So there's a number of difficulties because people end up simply being convicted and sentenced for their intention, even without actually participating in the crime.
The state calls Dumisani Kaleni, originally a co-accused in this case, now a state witness.
The state entered into a plea and sentence agreement with Dumisani Kaleni, the security guard who kept watch at the scene of the crime, so that he could shed some light on what happened that night.
Mr. Kaleni, what position did you hold at the time of the incident in question?
I worked as a private security guard for HM Security as a night patroller.
What role did you play in the break-in and attempted theft?
I was contacted by the group of accused and paid to act out as a lookout for them.
What were your co-accused instructions? Were anyone to appear at the shop?
They told me to get rid of anyone who came.
What weapons do you carry on patrol?
We're not allowed to carry guns, but I had a baton and a taser gun.
Were you given any specific instructions as to use force if somebody did show up at the shop?
They never told me exactly how to deal with that, but they knew I was carrying weapons and never told me not to use force.
Thank you. No further questions, milady.
The defense may cross-examine.
Mr. Kaleni, were any of the men armed with any dangerous weapons when they approached the location?
No, not that I could see.
Did the group of co-accused equip you with their own walkie-talkie so as to warn them if anyone was approaching so that they could not be noticed?
Yes, they did.
At any point during the altercation, did you try and help the inspector or radio for help in an attempt to stop the situation from escalating?
No, I didn't.
No further questions, Your Ladyship.
Now, in these cases where there are multiple accused committing a crime where they all do it together, often the state doesn't have any evidence from the outside about what actually happened. You know, you might have the odd person arrested on the scene, some of them may get away, and it's necessary to conduct the state case to know who did what, when, who planned the operation, who was the ringleader, what the objectives of the operation were, etc. Now, often that evidence is missing unless you actually get that from one of the perpetrators. So what the prosecutor will usually try and do, if it's necessary, is to try and find someone, A, who's willing to talk, and B, who probably has a lesser role to play in the crime. So that in that case, you can think about doing some sort of a deal with that person in the interest of justice to prove the case properly so that the truth of the matter can come out.
Coming up, will Mundler's testimony convince the court that the gang had taken every precaution to avoid being caught? Or will their lack of a getaway plan hold any weight in the court's eyes?
We planned the job specifically so that we would not need any weapons. We did not want anyone to get hurt.
Mr. Shabangu, were you and your co-accused armed with any weapons?
No, we did not need any.
You were robbing a store. Why did you not need a weapon?
We planned the job specifically so that we would not need any weapons. We did not want anyone to get hurt. I mean, well, none of us know how to hold a gun, let alone to shoot.
You claim that you prepared this operation with the intention of not hurting anybody. How so?
We paid the security guard to keep a lookout. We knew how to work quickly and quietly, and everyone had a job to do. We wanted this to be in and out operation.
Mr. Shabangu, where were you and your co-accused standing when the deceased stood guard at the back door?
We were inside, moving the stuff. We had no idea that the police had arrived. The guard did not tell us anyone was coming until the gunshot. So we had no idea that Andile would run and attack the officer.
Thank you, Mr. Shabangu.
In this case, the court put much emphasis on the fact that the co-perpetrators went to the scene of the crime unarmed, and therefore there could not have been any reason for any one of them to foresee that a weapon will be used to kill somebody or even to attempt to kill somebody. But the situation would have been different if one of them had a firearm, because they will be in a position to say, if that firearm has been used from the very beginning, all of them should have realized that at some point the firearm will be used, and they will have reconciled themselves with that eventuality. But because of the absence of any weapon, no one foresee that somebody was going to be harmed.
Mr. Shabangu, You and your gang were well aware of the risks involved in attempting a break-in and theft, not so?
What do you mean?
I put it to you that you knew that if anyone were to pass by or the alarm went off, that the police would arrive armed. How were you planning on dealing with the situation if the police arrived, or anyone else for that matter, to spoil your plans?
We really thought our plan would work, and that would not happen.
There is a grave difference between thinking and knowing, Mr. Shabangu. Did you have a getaway strategy if you were confronted?
No, not for when the police come, but we...
So everyone was free to create their own strategy if the situation arose?
No, we agreed to stick to the plan.
A plan, Mr. Shabangu, that did not seem to have a clear getaway strategy. Did you have a getaway strategy at all?
No.
The entire plan was premised that this will be, in a simple language, a perfect crime. There will be no confrontation with the authorities, to the extent that the only security guy that was there was also taken as part of the plan, so that to avoid any confrontation. So the confrontation that Andile had with the police was not foreseen by any of his colleagues.
After considering the arguments put forward by the prosecution and the defense, Judge Highland reconvened the court to announce her final verdict.
The common purpose doctrine does not require each participant to know or foresee every detail of the way in which the unlawful result is brought about. The state did not prove beyond a reasonable doubt that the conduct of the deceased in utilizing a housebreaking implement to resist arrest by attacking an armed police officer was foreseen by the co-accused. In acting as he did, the deceased embarked upon his own way, what the defense accurately described as a frolic of his own. The state has also failed to present the court with evidence that the now deceased and its co-accused had any intention of harming any member of the public or, for that matter, Inspector Daniels. What is clear to the court is the gang's intention to avoid such a situation by means of thorough planning. On the counts of housebreaking and attempted theft, I find co-accused 1 and 2 guilty. On the counts of the murder of Andile Maule and the attempted murder of Michael Daniels, I hereby find co-accused 1 and 2 not guilty.
As the brothers contemplated their fate, they could consider themselves fortunate that they were acquitted of the serious charges of murder and attempted murder.